Thank you.
All right, sir, did you have anything?
Yes, I do. Detective Casey already testified. What would be the significance of him testifying again?
Well, let's take that up later. I want to deal with the lab analysts who are here first and not delay their testimony any further. So, other than that issue, do you have anything else?
Yeah, I thought he was released from his subpoena. At least that was my guess.
I honestly don't recall whether that question was asked of me. I know he's the court officer and he's been here. I'd have to take a look at the record from when he testified and see if there was any reservation or have the state make an offer of proof and we can go from there, but I'm not going to do that right now. I want to have those lab analysts testify they're here and we can take up more fully the issue with Detective Casey after they're done testifying.
So how late do we plan on going?
I will go as late as 6 o'clock if need be. So I want to keep pushing along.
Yeah, that's definitely pushing it here.
That's not that late, sir. We've stayed till 5:36. Previously, there were times during jury selection we stayed till probably 7 or 7:30. The last two nights we did break at about 4:30, 4:45, and so I'm willing to go a little bit later tonight. So it's 3:30 now. We'll see how things go.
I was making that saying that on the record because in my position that is kind of late.
Well, let's start now and we'll get going, and maybe we don't have to go that late. So bring the jury out.
Are we going to address subject matter jurisdiction?
The written decision that I previously entered is what I will stand on. I'm not going to address it any further.
Is that verified proof?
Sir, my written decision is the decision on subject matter jurisdiction.
Is it verified proof? Because it hasn't been proven on the record, and that was not verified proof. It has yet to be proven.
Denying the request by the defendant to verify subject matter jurisdiction. That's denied.
It has to be proven for the record.
I disagree with you as a matter of law. The jury's coming out.
Lawful law.
All rise for the jury.
Show me by lawful law. Unless you make an tacit agreement that you don't have to prove subject matter jurisdiction on the record by law.
All right, welcome back, ladies and gentlemen of the jury. It's about 3:37. I know you're all filing in, so I'll wait till you all get in.
Not yet.
And welcome back to the rest of you who are filing in after our short afternoon break. I just wanted to let everyone know I have let the parties know if need be. I'm willing to stay between 5:30 and 6 this evening. I know there's 2 witnesses for sure the state intends to call, and I intend to get through. It's kind of the timing and whether there's a 3rd witness tonight or not. I'll decide a little bit later. But at this point, the state may call its next witness, and the rest of you may be seated, of course.
Thank you, Your Honor. The state calls Chris Johnson.
All right, Mr. Johnson, if you would please make your way to the witness stand, which is on my right. It is up a riser. When you get there, please remain standing. Raise your right hand. My clerk, Teresa, who's on my left, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, sir. Please have a seat. The first thing I will ask you to do is to state your first and last names for the record and then spell each.
My name is Chris, C-H-R-I-S, Johnson, J-O-H-N-S-O-N.
Thank you. Go ahead, your witness.
How are you employed, sir?
I'm employed as the Chief of the Office of Crime Scene Response for the Division of Forensic Sciences, Wisconsin State Crime Laboratories.
What is your educational background and training, briefly?
I have a Bachelor's of Science degree in molecular biology from Marquette University. I started my career approximately 16 years ago in the DNA analysis unit as a forensic scientist. As a forensic scientist, I went through an extensive training program to be a DNA analyst, and I've carried many positions since then.
And as chief of the crime response unit, what are your duties and responsibilities?
My duties are twofold. I have an administrative aspect and a technical aspect. The administrative aspect is to oversee and monitor all operations or all aspects of the crime scene response program operations. My technical aspects come into play when I receive calls from law enforcement to respond to scenes to provide technical assistance. My primary duty as the technical aspect is to preserve the integrity of the evidence at crime scenes. This is done through proper examination, recognition, documentation, and collection of physical items of evidence. Furthermore, another technical aspect I have is to write confidential reports of findings, and this basically summarizes any examinations and processing techniques that are used on scene and is a summary of the findings from those techniques. Lastly, I testify in court when needed.
Is there a set procedure you follow when you are asked to respond to a crime scene?
Yes.
What is that, please?
Objection leading.
Overruled. The witness may answer.
If law enforcement is at the scene and would like the crime lab crime scene response team to respond, they simply call the lab that's in their jurisdiction, and basically the call will get routed to me and I'll dispatch a team to the scene.
And on November 21 of 2021, was the crime scene response unit asked to respond to an incident in the city of Waukesha, county of Waukesha, state of Wisconsin?
Yes.
What was the nature of the call?
The nature of the call was to respond to an address on Maple Street to begin processing a vehicle that was abandoned in the driveway of that residence.
Were you given any limited information as to the significance of the vehicle?
Yes, it was reported to me that the vehicle was more than likely involved in running through the Waukesha Christmas parade.
Were you aware that it was reported pedestrians had been struck during the event?
Yes, that was reported.
The objection is noted. I'll allow it as it is foundational. The witness may answer.
Yes.
Now, when I think of a crime scene, I typically think of a place or a location. Does your unit also cover processing of a vehicle like this?
Yes, in this
Overruled. You may answer.
in this particular circumstance or situation, the vehicle itself can be considered a crime scene in and of itself.
And in your years with the crime lab, do you have prior experience processing motor vehicles that were suspected to have been involved in fatal collisions with pedestrians?
Objection leading.
Overruled. Foundational. The witness may answer.
Yes, I've processed several vehicles related to that.
Okay. Did you personally respond to the address at 338 Maple?
Yes, I was one of two people responding.
Who else responded?
Julie Avila.
And does Julie work with you?
She does.
What's her task or primary responsibility?
Objection leading.
Overruled. Foundational. The witness may answer.
For this particular scene, I was what is called the team leader, so I'm in charge of all aspects of processing the scene. Julie was a crime scene response photographer, so she was tasked with appropriate documentation via photographs.
Okay. Do you recall about what time it was when you arrived on scene?
I arrived on scene approximately at 8:15 p.m. on 11/21/21.
And I'd like to show you a series of photographs, and I'm going to have multiple sets of photographs to go through with you. This is the first set, and the set contains 4 or 5 pictures. So they're going to show up on your screen first, sir, and I'm going to ask you to identify these photographs, and then we'll work backwards and present them to the jury with the court's permission, okay?
Okay.
So first on the screen is Exhibit 67, which I believe was previously admitted?
Yes.
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 All right.
Objection.
Overruled.
Sir, do you recognize the objects depicted in State's Exhibit 67?
Yes, this is a overview showing the front end damage of the red Ford Escape that's parked in the driveway of 338 Maple
Okay.
Avenue.
Next, we're going to present to you Exhibit 93. What's depicted in 93, please?
This is a close-up showing the damage of the front end of the vehicle, the red Ford Escape that's parked in that driveway.
All right. I should have asked you this prior to the photographing of the vehicle. Is it been moved or altered by you in any way, sir?
No. Objection leading.
Overruled. Foundational. The witness may answer.
No.
Please put up for the witness number 68, which has been previously admitted.
Go ahead.
Objection.
Overruled.
Please describe, sir.
This is the photograph's taken at an angle, the front passenger side of the vehicle, but again showing the damage of the front end of the vehicle.
Number 102. You recognize that photo, sir?
I do.
Please describe.
This is
Objection.
Overruled.
This is a mid-range photograph of the driver front quarter panel, showing a side view of the damage of the hood and the quarter panel.
And number 103. Please describe.
This is a overall photograph of the back end of the red Ford Escape.
Do you believe these 5 photographs are true and accurate depictions of the way the vehicle looked on the driveway at 338 Maple that evening, sir?
Objection leading.
I'm sorry, I was trying to get a hold of my witness list. Could you re-ask the question?
Yes, Your Honor. Do these 5 photographs truly and accurately depict the way the vehicle looked at 338 Maple Street on the evening of November 21, 21?
Objection leading.
Overruled. Foundational. The witness may answer.
Yes.
Move to admit 67, well, 67 and 68 are already in. So move to admit 93, 102, 103, and permission to publish all 5.
Objection. Relevancy.
Noted. Overruled. The exhibits are received. Permission to publish granted. Specifically, 67, 93, 68, 102, 103. I realize some may have been received previously, but to be thorough, I wanted to put that on the record.
Thank you. All right, Mr. Johnson, 67 you testified was an overview photograph?
Yeah, it's an overall photograph
Objection
of the.
leading.
Overruled. They're now being shown to the jury. It's proper. It's foundational as well. Go ahead.
Yes, this is a overall photograph showing the location of the vehicle, but specifically also showing the front end damage of the vehicle.
All right. Next, 93. Please describe.
A close-up.
Overruled. Go ahead.
A close-up of the damage that has been sustained on the front hood area, bumper area of the red Ford Escape.
Next is 68.
Objection.
Overruled.
Mid-range photograph showing the damage, front end damage, specifically from a reference point of the front passenger corner of the vehicle.
I observe on the bottom of that photograph there appears to be some liquid substance on the ground. Do you see that, sir?
Yes, I
Objection
do.
leading.
Overruled. Foundational. The witness may answer.
Do you remember seeing that substance that night?
Yes.
Were you able to tell what it was?
Objection speculative.
Overruled. Based upon his training and experience, he may answer.
Not specifically what type of fluid it is, but some kind of engine compartment fluid.
From this vehicle?
Yes.
Okay. Number 102, please.
a mid-range of the driver front quarter panel, also showing what I describe as a white headband on the broken driver door mirror.
Is that illuminated in some fashion?
Objection
Yes.
leading.
Overruled. The witness may answer. Just a reminder to wait until I fully rule on the objection before you answer.
I apologize. Yes.
How was it illuminated?
Objection leading.
Overruled.
It has white LEDs that are within the cloth, and they're blinking on and off.
Okay. And then last would be 103.
Objection.
Please describe. Oh, I'm sorry, he objected.
Overruled. Go ahead.
An overall from the further into the driveway showing the back end, the rear end of the red Ford Escape.
All right. Now, after these photographs were collected on Maple Street, did there come a time where you planned to move the vehicle?
Yes. Part of the process in arriving at a scene, there are 3 steps. There's a scene approach, scene assessment, and a scene processing strategy. So the scene approach starts with the moment I receive a call and start thinking about what evidence might be present, just knowing the limited facts or the limited information that I have during the call. When I arrive on scene, I do a scene assessment. So I did a walkthrough of this particular vehicle, around it, and including the property. Determined from that what my processing strategy would be. So going back to answer the question, my thought and my processing strategy this particular night was to collect anything that would be fragile in nature off of the vehicle and then get it transported to a more environmentally friendly secured facility to continue processing in the subsequent days.
Was that for your comfort or for some scientific reason?
Objection. Speculative.
Overruled. The witness may answer.
It was very cold that night, so it was difficult to process. It was very windy, but it was for a purely scientific standpoint of doing the necessary steps of collecting whatever I needed and I deemed fragile. Collect that stuff, and then let's get it into an enclosed trailer and transport to a secure facility that's nearby.
So what items, if you recall, did you remove that you had deemed fragile?
Objection leading.
Overruled. The witness may answer.
There were first some items that were in the yard of this particular residence, some examination gloves, and a winter hat that was in the backyard. So those items were collected. Of particular interest on the vehicle was the headband that was around the driver door mirror that was broken. So that was important to collect because during transport, that most likely would have fallen off. So that's what I'm talking about, fragile evidence.
Okay. So that item was removed?
Correct.
What about the front bumper? We saw that laying on the driveway. Was that secured in some fashion?
Objection leading.
Overruled. You may answer.
Yes, to make transport easy, the bumper would have had to be lifted up with bungee cords and resecured. Otherwise, as the tow company is moving the vehicle, the bumper would just continue to go underneath the vehicle, further damaging or maybe even eliminating or getting rid of physical evidence that might be on that bumper.
So were you the person that secured that front bumper?
I was there and I assisted with the tow company.
Okay. Where'd you take it?
So it was taken from this residence and it was taken to Waukesha County Sheriff's Office secured facility.
Is that nearby here in Waukesha?
Yes.
Okay. Ask Madam Clerk if you could turn off the display, please, and I'm going to present to the witness only another series of photographs, starting with 105.
Go ahead. Do you know how many?
8.
Sequential?
Yes, 105 through 112.
Thank you.
Objection. Relevancy.
Well, I haven't seen them yet, so I'll have to wait, but you can put them up and then I'll make a ruling.
I think we're ready on our end. We're just waiting for Madam Clerk.
Oh, sorry. I'll leave it alone. You hit it. Just mixed each other twice.
105.
All right.
There.
Given what I see on the screen, the objection is overruled.
Okay. And, Your Honor, for the sake of time, I'm just going to ask the witness to look through these photos just as if he had them in front of him, and then I'll ask some foundational questions. So 105 is on the screen. Do you see it, sir?
Yes.
Do you need more time to review that photo?
No.
106, please.
Yes.
Do you need more time to review that photo?
Objection
No.
leading.
Overruled. The witness may answer.
107,
Yes.
do you need more time?
No.
108,
Yes.
do you need more time?
No.
109,
Yes.
need more time?
No.
110,
Yes, I recognize, and I don't need more time.
111,
I recognize, and I don't need more time.
and 112.
I recognize that photo and don't need any more time.
Where were each of these photos taken?
Each of these photos were taken at that secure facility that where Waukesha County Sheriff's Office, their secured facility. This is indoors at that facility.
Okay. And do you believe each of these photos is a true and accurate representation of what the vehicle looked like once you towed it to the secure facility?
Yes.
A move for admission of 105 through 112 and permission to publish, Your Honor.
Objection.
Noted. Exhibits 105, 106, 107, 108, 109, 110, 111, and 112 are all received. Permission to publish granted as to all.
So in this photograph, sir, is the, what's the condition of the front bumper, please?
Objection leading.
Overruled. Foundational. The witness may answer.
The front bumper is secured in somewhat, should be its original position with those bungee cords that we previously talked about.
Okay. Next, 106, please. Please describe.
Overall photograph, the front driver's quarter panel, including showing the hood damage.
Was there an effort by you to try and match the pieces of the bumper to the frame of the body, or is that just the way it came together?
Objection. Speculative.
Overruled. Go ahead. You may answer.
At this time, I was not trying to physically match anything together. It was just for the purpose of securing it for transport.
Okay. What is the position of the driver's side window in this photograph, sir?
The window is down.
Is that the way you found it?
Yes.
Objection.
Overruled. The witness may answer. He responded to the scene where the vehicle was located and can testify based upon his knowledge.
107, please. Please describe.
An overall photograph from the point view of the front passenger side of the vehicle.
Next, 108.
Objection.
Overruled.
Please describe.
An overview of the front of the vehicle, including the front passenger quarter panel and the front passenger door.
What position was the front passenger window in?
Down.
Is that the way you found it?
Yes.
Okay. 109. Please describe.
An overall photograph of the passenger side of the vehicle. Including in this photograph is the front quarter panel, the front passenger door, and the rear passenger door.
And along the front passenger door and the rear passenger door, do you see anything remarkable?
Objection, leading.
Overruled.
Spanning the length of both doors is quite a significant scratch.
Have you seen scratches like that before in processing motor vehicles, sir?
Objection, relevancy.
Overruled.
I have.
What is that consistent with, please?
Objection, leading.
Overruled.
Coming into contact with another item.
Thank you. Number 110. Please describe.
An overall photograph showing the rear of the passenger side of the vehicle. Specifically noting that the rear passenger window, that window is not down, it was actually shattered,
Okay.
broken. And also showing in this photograph are 2 apparent fired bullet defects.
Okay, I have some other photos more specific to that in a minute. Thank you. 111.
Objection.
Overruled.
Please describe.
An overall photograph from the vantage point of the rear passenger side of the vehicle.
And then 112, please.
Objection.
Overruled.
An overall of the vehicle from vantage point, rear driver side of the vehicle.
Is the rear driver's side window, what position is it in, please?
That is up.
And is that the way you found it?
Yes.
And it looks like there's a substance on the exterior of the vehicle on the driver's side. Do you see what I'm referring to, sir?
Objection, leading.
Overruled. The witness may answer.
Yes, I do.
Do you know what that item or substance was?
Objection, speculative.
Overruled. Based upon his training and experience and his personal observation of the vehicle, he may answer.
Not knowing what specific fluid that might be, I did do a presumptive test to see if it's possibly blood.
Okay.
All tests that I did of that liquid that's on the driver's side came back negative for
Okay.
the possible presence of blood.
And was it sprayed along most of the driver's side of the vehicle?
Objection, speculative.
Overruled.
Yes.
Okay. Now, I'd like to move on, sir, and ask you, did you do an interior inspection of the vehicle
Yes.
and an exterior inspection of the vehicle?
Correct.
I'd like to highlight some specific areas, starting with the interior of the vehicle. Would you have processed the entire passenger compartment and cargo space of this vehicle?
Yes.
And what types of things would you have been looking for, sir?
Based on my former experience, looking for surface types that might contain potential DNA evidence. So specifically, anything that's in the vehicle that would have been handled to control the vehicle or handled in a repetitive manner or with some kind of force. So for example, the steering wheel, the gear shifter, those items were swabbed by myself for the potential of DNA. We also looked at surfaces within the vehicle and processed those for the possible presence of latent fingerprints.
Do you remember locating an object on the front passenger seat of the vehicle?
Yes.
I'm going to ask that we display to the witness only Exhibit 117. Do you recognize what's shown in Exhibit 117, sir?
Yes, there's a hat that's on the front passenger seat cushion.
Is that the way the object looked when you found it?
Yes.
Move to admit 117, permission to publish, Your Honor.
Objection. Relevancy.
Overruled. Exhibit 117 is received. Permission to publish granted.
Could you please, it's a touch screen in front of you, circle the hat that you just described for the jury? And then to your left, sir, on the witness stand, before you took the stand, I placed an item up there that's been marked as exhibit number 87. You see that on the table there?
Yes.
Can you identify exhibit 87?
Yes, this is the winter style hat that I collected from that front passenger seat.
Okay. I'd like to show another photograph to the witness, exhibit 118, please.
Objection.
Overruled. Go ahead.
Do you recognize the object in exhibit 118?
I do.
Do you believe this photo is a true and accurate representation of the object as you found it on the vehicle?
I do.
Objection. Speculative.
Overruled. Your answer may stand again. Just wait till I rule on the objection, please.
Move to admit 118, permission to publish.
Exhibit 118 is received. Permission to publish granted.
Please describe.
This is a close-up photograph of the clothing items that were pinned to the windshield by the crumpled hood, and it was being held in place by that hood pinning the items against the windshield, as well as that wiper arm.
Okay. Did you eventually remove these items?
Yes.
What did you find them to be?
It was a detachable hood from a jacket as well as a winter hat.
And can you just point out on the touch screen which is which?
Objection. Leading.
Overruled.
That's the hood portion, and that's the hat portion.
Okay, thank you. Did you find any U.S. mail or paperwork inside the vehicle?
Objection. Relevancy.
Overruled. The witness may answer.
Yes, I did.
Were there any names associated with the U.S. mail or paperwork inside the vehicle?
Objection. Relevancy.
Overruled. The witness may answer.
Yes.
What was that name?
Darrell E. Brooks Jr.
Was there an address, if you can recall?
Objection. Relevancy.
Overruled. The witness may answer.
There was, but I don't exactly recall it.
Sure. Also on the table next to you, sir, is your report that I've marked as exhibit number 90. Do you see that?
Yes.
Wait. Placed on the table.
Go ahead, Attorney Opper.
Well, objection. How did it get on the table?
Your objections noted. It's overruled. Record will reflect that there's a copy of a crime lab report. It has an exhibit sticker, number 90, with the case number of this case. Handing it back to the witness. Go ahead, you may question.
How did it get on the table? Who placed it on the table?
Attorney Opper indicated she placed it there.
When did that happen?
Attorney Opper, go ahead, continue.
Did you author this report, sir?
Yes, I did.
If you review the report, would you be able to see the address for Darrell Brooks that was noted in the paperwork from the inside of the SUV?
Objection. I don't consent to being called that name.
Please
Noted.
do.
Overruled.
Yes, I would.
Please do that, sir.
Objection.
Overruled.
Grounds for the overrule.
The witness may answer.
Grounds for the overrule.
Go ahead, sir.
The address for the pieces of mail that I recovered was 4014 North 19th Street, Milwaukee, Wisconsin, 53209.
Thank you.
Objection, that should be strike. When he asked the question, he said he didn't recall. So how can you force somebody to recall?
The witness's recollection was refreshed through the use of his report, which he indicated he documented the address. Your objection is noted. It's overruled. The answer will stand. Go ahead. Next question, please.
Yes, and actually, if I could back up 1 minute and ask Ms. Gussie to put back up 117. Got to ask a question about 117.
Go ahead.
And if we could display it,
just need to do
please,
what y'all
Madam
wanna
Clerk.
Nobody got to answer no questions.
Mr. Brooks, please refrain from interrupting. You'll have an opportunity to ask your
I have an
questions
objection
on
of
cross.
how stuff got to the table without my knowledge. That should be known. That should at least be noted for the record.
It was
I
noted for.
wouldn't be able to do that.
Your objection's noted. It's overruled. Go ahead, Attorney Opera.
So that needs to stop happening.
In
It needs
addition
be
to the
fair.
All right, I'm going to excuse the jury.
Can't keep doing stuff without. It should be a fair trial. That's my right. You shouldn't be able to do things without my knowledge. And then pass it off to the jury like that's fair. They deserve to know that too.
The rest of you can have a seat as well. As soon as the jury's out, I'll make a record. All right, Mr. Brooks, you are well aware that the reason
consent to being called
documents
that
are
name.
being put on the
I don't consent
witness
to being
stand
called that name.
are because this court indicated it would limit the movement of the parties due to your custodial status to keep things fair.
And I
You
merely
are
asked, how
attempting-
did it get there?
Sir, do not
I'm
interrupt me, or
I'm-
you will
I'm not
forfeit your
entitled
right
to
to be
know how I got
present
there.
in this courtroom.
So
Do
you're
not
holding me in
interrupt
contempt?
me.
Are you holding me in contempt?
I'm going to make a record.
Are you holding me in contempt?
I'm not answering your questions.
So then you're not holding me in contempt.
Do not interrupt me again, or you will go to the other courtroom.
Under what lawful law?
All right, he's interrupted me once again. We're going to clear the courtroom. He's being disrespectful. I'll make a record once he moves. Unless you can promise me right now that you let me make my record without you interrupting me, sir.
You gonna make your record? You can make your record.
Then please don't interrupt me.
Don't hold me in contempt.
I've never said any such thing.
Removing me from the courtroom, Your Honor, is essentially holding me in contempt.
All right. No, you're forfeiting your right to be present under Illinois versus Allen.
I didn't forfeit anything.
I'm going to start talking, and if he interrupts, then I will close this courtroom, and he will be taken to the next courtroom. Mr. Brooks, you are well aware that the court made some pretrial rulings related to whether there would be, they can stay in, I haven't closed it yet, he's not interrupting me, whether the parties could approach the witness stand. And I did that because you're in custody, and I'm not going to allow you to approach the witness stand while in custody. That is why various precautions have taken place to limit, frankly, that from happening. Throughout this trial, there was one instance at the very beginning of the case where I allowed the state to approach a witness. I corrected that. That hasn't happened since. We've had bailiffs take items up to the witness stand, or the items have been given to the witnesses, or they've been placed on the witness stand. That's proper. There is nothing wrong about that. Nobody's trying to pull a fast one over you. No one is doing something that's not permitted by this court, or frankly under the rules of decorum and courtesy, or the presentation of evidence in this case. Frankly, from my perspective, sir, your attempts and your comments are to try to dig in at this jury and to somehow create doubt about the presentation of this case or the fairness of these proceedings without the party, meaning the state, having an opportunity to refute, explain, or correct it. I've taken the jury out at this point to admonish you that any further mumbling under your breath or not recognizing when I uphold or sustain an objection, that I will take as a disrupting interruption meant to disrupt the proceedings. I'm not holding you in contempt. I'm well aware that that's one of my options. I choose not to do it for the reasons that I've stated on the record previously. All right, you can forfeit your right to be present at any point in time during this trial by your conduct under Illinois versus Allen. When it is disruptive, when it does not follow the simple rules of courtesy and decorum, I draw your attention once again to SCR Chapter 62, which has been previously provided to you, which is under the statute there. These constant mumbling and interruptions during the proceedings. I haven't made a record of them today, but I will now. Started at 9:01, then there was 5 at 9:02, 3 at 9:03, 4 at 9:04, 1 at 9:05, 2 at 9:05, 1 at 9:06, 3 at 9:08, again at 9:17, 9:27, 10:31, 1:05. There was talking over by you at 2:03, 5 interruptions at 2:14, 2:15, 2:17, at 2:19, audible muttering, 2:31, 2:33, what I would describe as inappropriate, like muttering under your breath, 2:35. At 3:06, there was a hilarious comment. At 3:11, there was what I would describe as arguing about the muttering and the irony of it all. At 3:12, there were 4 interruptions. At 3:37, more 4:09, 4:10, more mumbling. At 4:11, twice, and at 4:12, 9 different times. So I think I've made an ample record of the disruptions today. I've been abundantly patient with you. Again, as I stated earlier, I've even limited how I tell these things to the jury about how to disregard, and I simply say the jury is to disregard comments and statements made by the parties or the lawyers, as those are not evidence. So I'm warning you, do not interrupt again. If this jury comes back or when they come back and you do that, then you will be removed and you will forfeit your right to be present for the examination of this witness. Let's bring the jury back in.
Well, you might as well remove me then, because what you're doing is not fair. I can't even rebut what you're saying. I didn't interrupt you. I let you make your incorrect record.
Mr. Brooks, I'm bringing the jury out and we're continuing. We're going to get through these witnesses.
Okay? And I'm not stopping you from doing that.
Through your behavior, you're not going to delay these proceedings today.
I'm not trying to delay the proceedings, so I wish you would stop being incorrect on the record and saying what I'm trying to do if you don't know that. You don't know what I'm trying to do.
I'm bringing the jury out. I'm not going to argue with you.
Then don't. Because I'm not arguing with you either. I'm stating facts.
You're raising your voice. It's
because I'm tired of you always making a record.
At me.
You're making a record of me trying to look bad. I know what you're trying to do. It's not going to work.
I'm making a record of what's accurately.
You're making a record of incorrect statements. That's what you're doing. You're not making a record of not being.
I'm advising you to be quiet because the jury's coming back out.
You're advising me to be quiet. Is you telling me to be quiet?
I'm advising you to be respectful when the jury comes out.
Are you telling me to be quiet, or are you asking me?
I'm asking you and advising you.
Thank you for correcting that, because don't nobody tell me what to do. I don't tell nobody else what to do.
I'd appreciate
we're all adults in here. I've never told you to do anything at all.
Sir, I'd appreciate if your tone of voice would change.
I would appreciate if you would ask me. I'm a grown man with grown kids. Ain't nobody gonna talk to me like that. Nobody. I don't have a problem with doing what you ask me to do, not tell me. Just like when I asked you about subject matter jurisdiction that you have yet to prove on the record. But somehow I'm being intentionally disruptive. Come on, man. Stop. Just stop it.
Jury's coming out.
All rise for the jury.
Not going to work. I'm supposed to be scared of getting removed or something.
Thank you, everyone. Please be seated. Statement continue its examination of this witness. I believe we're on Exhibit 117.
Yes, we have 117. If Madam Clerk, would you please turn the display back on? Mr. Johnson, were there other items on the front passenger seat besides the blue winter hat?
Objection leading.
Overruled. The witness may answer.
I do recall a cell phone being present on that front passenger seat.
Do you remember what kind of cell phone?
An iPhone.
I also see some items that look like maybe headphones or charging cables, something like that. Do you see that,
Objection
sir?
leading.
Overruled. Foundational. The witness may answer. The exhibits have previously been received.
Objection speculative.
Overruled.
I do see that.
Do you remember something like that on the front passenger seat?
Yes.
Okay. And how about on the floorboard of the front passenger seat? Is there an item there, sir?
Objection leading.
Overruled. You may answer.
Yes.
What do you remember that item was?
A TV.
Okay. And to the left of the TV, the white colored object?
I don't recall what that is.
Okay. But this is the exact way the passenger seat looked when you recovered the vehicle, correct?
That's correct.
Okay. Now if we could please go to Exhibit 116 and put up for the witness only. Sir, do you see Exhibit 116 in front of you?
I do.
Do you recognize this photograph?
I do.
Do you believe this to be a true and accurate depiction of the interior of the SUV?
Yes.
Move to admit 116, permission to publish.
Objection. Relevancy.
Overruled. Exhibit 116 is received. Permission to publish is granted.
What's in the photo of 116, please?
This is an overview of the rear passenger seat. That rear passenger compartment contained several clothing items and miscellaneous items.
Okay. And was the condition of the back seat like this when you found the vehicle, sir?
Objection speculative.
Overruled. The witness may answer based upon his knowledge of recovering the vehicle from the scene and his training and experience.
Yes.
Now for the witness only, I'm going to please ask Ms. Gussie to put up 113, 114, and 115 for his review.
Go ahead.
113 up?
Yes.
Okay, do you recognize that item?
I do.
Okay. Next, 114. Do you recognize 114?
Yes.
And 115, do you recognize 115? There it is.
I do.
Okay. Do you believe these three photographs truly and accurately depict the vehicle, these areas of the vehicle, sir?
Yes.
Move to admit 113, 114, and 115, permission to publish.
Exhibits 113, 114, and 115 are all received. Permission to publish granted.
Please.
Jury would let me know when the jury box monitors are on. All right, thank you very much.
All right. Please describe 113, sir.
That is an apparent fired bullet defect that's in the windshield of the Ford Escape.
Is that the rear view mirror on the left side of the picture?
Yes, this photograph would be from the inside looking through the windshield.
Were you able to tell the path of travel for the bullet?
Objection
Yes.
speculative.
Please describe.
Overruled. You may answer.
Yes. The fired bullet that caused this defect most likely came through that rear passenger window that was shattered and entered the vehicle and then exited the vehicle through the windshield.
So that's a exit damage that we're seeing there.
Yes.
How can you be sure?
Windshields have laminated glass, and so the directionality of a fired bullet going through laminate glass, there's an indicative laminate tag, we call it. So that shows the direction of the fired bullet.
Okay. Number 114, please. Please describe.
That's an apparent fired bullet defect. I call this a striking defect. That's on the roof rail of the passenger side of the vehicle.
Okay. Why do you call it a striking defect?
It didn't penetrate any part of the vehicle. It was more of a glancing kind of ricochet.
Okay. And then number 115. And if you could zoom in on that back left. Yep, thank you. Please describe.
This is an apparent fired bullet defect. I call this a perforating defect because it actually went through the exterior door skin and went all the way through into the inside of the vehicle.
Did you ever find the fired round in the vehicle?
Yes, I did recover a fired bullet and fired bullet fragment from the rear cargo area of the vehicle.
Okay. Was there any evidence that that bullet traveled any further than the cargo area of the SUV?
Objection. Speculative.
Overruled based upon the witness's training and experience and examination of the vehicle. He may answer.
No, the bullet stayed in that rear cargo area.
Okay. Now, aside from examining the interior and the exterior of the vehicle at ground level, did you attempt to look underneath the vehicle?
Yes, the first processing strategy, if we go back to that, I wanted to get everything collected from all sides of the vehicle and inside of the vehicle before putting it on a vehicle lift to examine the undercarriage of the vehicle.
So you did do that.
Yes.
What kinds of things are you looking for on the undercarriage?
Looking for anything that shouldn't be normally present on the undercarriage of the vehicle. So I was looking for any hairs, fibers, any potential biological fluids such as blood.
Did you find any such objects?
Objection. Leading.
Overruled. He may answer.
Yes, I did.
Did you collect those items?
Yes, I did.
You had described for us earlier swabbing of the steering wheel on the interior of the vehicle. Do you recall that?
Objection. Leading.
Overruled. The witness may answer.
How do you go about swabbing a steering wheel, sir?
Objection. What's the relevancy?
Overruled. The witness may answer.
The best way to collect DNA evidence from a surface is to use a two-swab technique. The first swab is a swab that's slightly moistened with deionized water, and basically swabbing the surface and then following up that swab with a dry swab. So it's a two-swab process, a wet swab followed by a dry swab, and that becomes one item of evidence.
Same thing for the gear shift?
Yes.
What do you do with these swabs after you collect them?
I put them into the appropriate container and then seal that container, write my description of that particular item of evidence, and eventually that evidence is transferred to a unit at the crime laboratory for analysis. In this particular case, those items, anything for DNA, is going to be transferred to the DNA analysis unit.
Did that happen?
Yes, that did.
And how about the hat, States Exhibit 87? Did that get transferred to another unit for further analysis, to your knowledge?
Yes, so any clothing item that's...
Hold on. There was an objection.
Sorry.
Grounds?
Relevancy.
Overruled. The witness may continue answering.
Clothing items that are worn by individuals are a really good source of transfer of DNA. So yes, I collected that hat and it was transferred to the DNA analysis unit.
Your report Exhibit 90, did you believe that to be a true and accurate narration or summary, I should say, of your work in this case, sir?
Yes, I do.
Move to admit number 90, Your Honor.
Objection. Relevancy.
Overruled. Exhibit 90 is received.
I don't have any other questions then, Your Honor.
All right. Thank you. Cross-exam, please.
said you do DNA analysis, correct?
No, I did DNA analysis for nearly 10 years. I don't actually do DNA analysis anymore.
So at the time of the incident, were you doing DNA analysis?
No.
So who did the DNA analysis on all the items that were found during your investigation?
DNA analyst Trevor Nailed.
Did you see the results of those DNA Did you see the results of those DNA tests?
We did have conversations.
Did you see them?
No.
So it'd be fair to say you don't know what those results were.
I didn't verify it. Like I said, we just had conversations.
So do you know the results of the DNA analysis?
In particular, is there a particular item?
For any of the items?
I don't recall the exact results, no.
And you made reference to the gunshot that you stated stayed in the rear cargo. Where in the rear cargo did you find that shell casing?
Objection, that's a misstatement. It wasn't a shell casing, Your Honor.
Shell casing, fragment, same thing.
Hold on, there's been an objection. I'll sustain the objection. It mischaracterizes the testimony and ask that you rephrase it.
Did you find a shell casing? A bullet fragment?
I found a fired bullet fragment.
Where did you find the fired bullet fragment?
It was really close proximity to where the rear latch comes down and hooks in to stay closed. So on the floor of the rear cargo by where the actual cargo door comes down.
And you said a latch that comes down?
Yeah, so how doors latch, like car doors latch, you know where the latch is? So where the rear cargo door came down and latched, it was in really close proximity on the horizontal surface of that rear cargo area.
Did you observe if the bullet fragment had struck anything?
It struck some items in that rear cargo area.
Do you recall what it struck?
I don't.
You made reference to a headband being on the rear view driver's side mirror, correct?
Correct, it was on the driver's door mirror.
And from your expertise, how would you, in your opinion, guess that it got there?
By coming into contact with something or someone that was wearing it?
And do you know that for sure?
No, but based off of my experience of a lot of years of examination of physical items of evidence.
But it'd be fair to say that you don't know exactly.
No, I wasn't at the parade. No.
And you stated that you were present for the towing of the vehicle, correct?
Yes.
Do you recall at any time anyone's attempting to start the vehicle?
No.
And you stated that the bumper was, I guess, moved at some point so it wouldn't drag under the vehicle. I'm guessing that's what you said. If I'm wrong, you can...
No, that's correct. Yeah, we used bungee cords to secure it off the ground so that when we're moving it or putting it on the flatbed to go to the actual enclosed trailer, that it wouldn't be constantly going underneath the vehicle.
When towing the vehicle, what was it placed on?
Because of the amount of traffic or cars that were parked on the road, the towing company couldn't get the enclosed trailer right to the end of the driveway. So the vehicle was put onto a flatbed truck and then driven a few houses down, where then it was transferred to an enclosed trailer and then removed from the scene.
So with the bumper, being that it was first placed on a flatbed truck, as you say, at that time, what the bumper had, what problem would the bumper had caused if it wasn't going to be physically dragged or anything at that point?
I'm not sure I understand your question.
What kind of problem would the bumper pose if the vehicle was on a flatbed truck?
The whole point
Essentially what I'm saying is, to give you more clarity, how could the bumper be dragged at that point?
it was being removed from the surface of the driveway onto the flatbed. So if the bumper weren't secured in an upright position, it would be pulled, and the bumper, as the vehicle is going this way, the bumper would be pulled underneath the vehicle.
So once it was secured on the flatbed truck, would the bumper still pose any problem?
The vehicle on the flatbed, the bumper was in a secured position.
If it wasn't bungee corded, would it have posed a problem?
Yes.
How so if it wasn't moving?
The whole purpose was to secure the bumper in place to preserve any physical evidence that might have been on the bumper.
And do you recall who did the actual towing?
The company is Complete Towing and Recovery.
And you stated to wanting to get the vehicle to a environmentally friendly, secure location?
Yeah, a better term would be environmentally controlled.
What do you mean by environmentally controlled?
Proper lighting, outside of the elements, outside of view of the public, so an enclosed building.
Why the reference to outside of the public?
It's easier to do examinations in a controlled environment.
Would it be fair to say at that time, before it was towed, the vehicle had been secured, checked? That was done out in public. So, what would be the difference at that point?
I'm going to go back to my original statement of what my primary duty is. My primary duty is to preserve the integrity of the evidence. So that night, I was concerned with doing the necessary steps that I deemed relevant to collect, and then get that vehicle to a more suitable environment, just based off of how much more work and analysis and processing that vehicle would entail.
Fundamentally, I follow what you're saying fundamentally. The question, though, is, by the time you arrived to the scene where the vehicle was located, were you aware that the vehicle had essentially been already investigated?
No.
So you had no knowledge that the vehicle had been secured, had been pretty much investigated by that point?
Well, I was aware that the vehicle was in a secured state. I don't know what happened prior to that. There was very little information that I received on the initial phone call because of the hectic nature of everything. So I had an address, and I knew that the vehicle was being secured by law enforcement.
So law enforcement were present when you arrived to the scene?
Yes.
And at that time you had learned, did you learn any knowledge from the law enforcement other than what you were told during phone call?
No.
Do you recall who you were called by?
I was called by Special Agent in Charge Dave Kalbundi of the Division of Criminal Investigations.
Do you recall what time you arrived at the scene?
I arrived at approximately 8:15 p.m.
Do you recall what time the vehicle was found?
I don't recall.
Do you recall anyone telling you or mentioning what time the vehicle had been found?
I don't recall.
So it would be fair to say before you arrived on the scene, you have no knowledge of what's been happening around the vehicle.
That's correct.
You say you made reference to a hat being found in the background. Do you remember saying that? Or in the backyard, rather. I'm sorry, not the background, the backyard. I meant to say.
Yes.
And at the time that you observed this hat in the backyard, do you, from your expert opinion, do you recall it having any relevance to the vehicle?
No, it was an item of evidence or a potential item of evidence that just seemed out of place. So in those types of situations, I always collect those types of items.
But you weren't sure at the time if it had any involvement with the actual vehicle?
No.
Was there anything significant that stood out about the hat?
Just the location.
Did you find any blood on the hat? Did you find... Or is it just pretty much just a hat in the backyard?
I didn't do a thorough examination of the hat.
So as far as you were concerned, it was basically just taking in the evidence as a precautionary thing, or?
Yeah, it was an item that just seemed out of place, so I collected that hat.
Did you at any time obtain knowledge about the relevancy of that?
No.
All the photographs that you were shown, had you seen those photographs before today?
Yes.
Do you recall if they were taken the same night of your investigation or multiple nights or days, rather?
There were multiple days.
And do you recall why you had to, or do you recall why those photos had to be taken over a multiple day span?
Yes, the vehicle needed a comprehensive evaluation or processing examination of pretty much every single side and surface of that vehicle.
And to do that, photograph-wise, would have took days?
Yes.
So when did you start? When did you start actually doing an investigation of the items inside of the vehicle?
That would have been the 22nd, November 22nd.
So the next day.
Correct.
And so did you yourself do analysis of the outside of the vehicle?
Yes.
Same day, 22nd of November?
Yes.
So you kind of started the outside and the inside pretty much roughly at the same time?
Yes.
Do Do you recall how long your complete investigation took?
Mine along with my colleagues?
Yours.
Mine. The examination itself of just me examining the vehicle?
Just you.
Probably over 40 hours. And that does not include the report that I'm writing. It doesn't include the process of going through the report, everything. But my examination, at least 40.
And so I'm assuming you did the report after you completed the initial investigation part.
Yes, the report's a summary of my processing.
And define summary. What do you mean by summary?
It pulls everything together. It details my examinations and any findings I have from those examinations.
I always view summary as not every detail, but pretty much like it's much as would be relevant, but not every single detail. Would that be fair to say?
This report is comprehensive in the terms of it lists every single item that was collected.
So why would you refer to it as a summary?
It's a summary of the examination and processing. That's the best way to describe it. It's not a dictation, in other words.
What do you mean by dictation?
There are other reports that other agencies may do that are dictated, right? I did this, then I did this, then I did this. This is a summary. This isn't a dictated report.
So what exactly did you summarize in your report?
My examination and processing strategies that I used, and the items of evidence collected, and any relevant findings associated with those examinations.
Did you do any examination of the cell phones?
No, I collected those and transferred those to a detective with the Waukesha Police Department.
Do you recall who that detective was?
David, his last name is spelt, I believe, Foyen, Foyen.
So at the time that you turned the phones over, did you do any more work in regards to the phones?
No.
Do you recall doing any investigation on the airbag control module?
No, I don't do that.
Do you recall obtaining a search warrant to conduct an inspection on the ACM?
I'm sorry, I didn't understand you.
An inspection of what?
The ACM, I guess that would be the air control module. I'm guessing that's what that's
Thank you.
referencing.
No, since I don't do that type of analysis or examination, I didn't obtain any search warrant with that.
Any reason why I would say that in the paperwork?
Objection vague.
Grounds.
Sustained as to the form of the question. As to what paperwork you're referring to.
I'm guessing. I don't know what it will be called, but it says conclusion inspection summary. And the conclusion inspection or conclusion/inspection summary. Do you recall?
Is it from this witness?
Huh?
Is it from this witness?
Yeah.
Okay. Go ahead.
I don't think that is from this witness, Your Honor. I don't see anything like that in this Exhibit 90. Are you perhaps still looking at Inspector Schultz's report from the State Patrol, the last witness?
What page number do you have? And I'll take a look at it and I'll compare it.
This says page 5.
Yeah, he's looking at the last exhibit from Inspector Schultz, 83.
What? It says Chief Christopher Johnson.
Oh, it does say that in 83.
Yeah,
It says, if I can read for completeness, or you can, it says, upon arrival, I met with crime scene chief Christopher Johnson from the Wisconsin State Crime Lab.
No. That's not what I'm reading from.
Okay. Chief Johnson had obtained a search warrant to conduct the mechanical inspection and to image the data retained within the escape's airbag control module ACM.
Yes.
Correct?
Yes.
Okay. So that was written by Inspector Schultz, who just testified, not this witness, to clarify the record.
Thank you.
I apologize for that. It's all in the same paperwork with Chief Johnson, so maybe that's where the confusion comes in.
The record would reflect this witness. His last name is Johnson, so I think that's
Yeah,
understandable.
I didn't know. I was just reading what I have here.
Fair enough. Keep going.
Do you recall at any time obtaining any type of search warrants pertaining to the vehicle in this incident?
Yes, I have obtained a copy of the search warrant.
And do you remember what that search warrant was for? What was the intended search?
To search the vehicle and process it for any biological fluids, hairs, fibers, any electronic equipment, any personally identifying information.
And the ACM would fall under the lines of the mechanical side of.
Yes.
Okay. At any time during your inspection, did you observe anyone try to start the vehicle?
When I was with Investigator Schultz, when he came to my laboratory, he attempted to start it.
And after you already stated that your initial part of your investigation before the report totaled 40 hours. And at that time, after you had completed your report, did you do any more investigating in regards to the vehicle?
After my report was complete?
Yeah, after you had done the 40 hours that you stated with, and then the actual report.
No. Once my report's done, I didn't do any further examination of the vehicle.
And after that was completed, had you received any follow-up from law enforcement after you had completed everything?
No.
Had you yourself followed up with law enforcement about the investigation after you completed your initial part?
No.
You yourself didn't file any claims in this matter, did you?
No.
Do you know of anyone who filed any claims in this matter?
I don't.
And do you recall who you were subpoenaed by to testify?
I was subpoenaed by District Attorney Sue Opper.
Do you recall when that was?
I believe it was sometime, I don't exactly recall when.
And did you follow up on that subpoena
No.
after you had received it?
No.
Have you at any time seen or read any complaints in regards to this incident?
No.
Do you know who the plaintiff is in this matter?
The state of Wisconsin?
Would you label that as a person, an actual human? Grounds.
Sustained. Not relevant.
You ever actually seen the plaintiff in this matter? Grounds.
Sustained.
If you saw the plaintiff, would you be able to identify the plaintiff?
Objection,
Grounds.
irrelevant.
Sustained pursuant to 9611. Sir, please move on to a different line of questioning.
Just trying to establish who the plaintiff is, Your Honor. Do you see the plaintiff present in court today?
Objection,
Grounds.
irrelevant.
Sustained.
Would you consider yourself to be an injured party in this matter?
No.
No further questions.
Thank you. Any redirect?
Just very briefly. Mr. Johnson, you said when you arrived on Maple Street there were police officers present,
That's correct.
and you said the vehicle was secure at that point.
Correct.
Objection.
What do you mean?
Leading.
The answer may stand. Next question. Overruled.
What do you mean by that, sir?
The perimeter was secured with crime scene tape, and there were officers that were standing at the location where the vehicle was.
Would it have been possible for a member of the public or any curious person to just walk up and touch the vehicle or do anything to the vehicle?
Objection. Speculative.
Based upon his training and experience, he may answer. Overruled.
They would have been stopped by law enforcement.
Thank you, that's all I have.
All right, thank you, sir. You may step down. While he's stepping down, if my jurors and anyone else in the courtroom want to stand, I do want to get through one more witness tonight.
And then the exhibits that Mr. Johnson has, Your Honor, what would you like done with those?
I'll take them.
All right.
I have 90 and 87.
Yes.
What was 87?
87 is a hat.
I'm not sure if I did move that, but I would move that into evidence, so we will need that item for the next witness, please.
Okay, I'll put that back.
Thank you.
Objection to that.
Noted.
Before you showed me that, I didn't even see what that was. If you would have never told, I know, but if you never would have told me, I never would have even know what that was, and I didn't see it until you just moved it.
The witness had it up on the stand, but here it is. It's exhibit marked as Exhibit 87. Go ahead and say state has moved it into evidence. I believe there's an objection.
Yes,
noted,
there is an objection.
Overruled based upon the testimony of the prior witness.